Dear participants, a very warm welcome and above all, my best wishes for 2024. As president of the European Law Institute, it is my great pleasure and privilege to welcome you all to this kickoff webinar on our project dealing with succession of digital assets, data, and other digital remains. In September 2023, the ELI Council adopted this ELI project aiming at drafting model rules to harmonize key provisions on the definition of digital remains, access and inheritability, as well as issues of data protection. The project will help define and distinguish different types of assets, remains, and personal data, define their inheritability and transmission, as well as examine existing rules on applicable law, jurisdiction, data protection, and other relevant areas of law, with a view to ascertaining their sustainability for this field, failing which proposals may be put forward. Needless to say that this project is very ambitious, as it tackles not only various fields of substantive law in a comparative perspective, but also private international law issues. The work will be led by two co-reporters, Dr. Edina Arbinia and Professor Antoine Eigenmann, also specialized practitioners in inheritance law issues. Before listening to them, let me say how happy we are to have also wonderful panelists today. I will present them while we will get to them. Let me, however, before starting, remind you, as usual, that the chat function has been disabled, but you can and should put all your questions through the Q&A function. Please do not wait until the end to pose questions, but we will answer your questions then orally at the end of the formal presentation. Now let's start with our two co-reporters. Dr. Edina Arbinia, she is a reader in media privacy law at Ashton Law School, Ashton University in the UK. Her principal area of research and teaching is related to the legal issues surrounding the internet and emerging technologies. Edina is a pioneer and a recognized expert in post-mortem privacy of the deceased individuals. She has published widely on aspects of technology and law and regulation, including online safety. Edina holds an LLB from the University of Sarajevo in Bosnia and Herzegovina, and an LLM degree from Strathclyde University in Glasgow. She was awarded a PhD from the same university. She has been a visiting professor and invited speaker to many universities across the world. Antoine Eigenmann, he's been lawyer for more than 20 years, specialist in inheritance law and member of the bar in the canton of Vaud in Switzerland. He's also a qualified mediator. He holds a PhD in law from the Faculty of Law at the University of Fribourg in Switzerland, and is professor of inheritance law at this university as well. In his daily practice, he deals mainly with complex international and transnational inheritance cases, and he's also the author of numerous publications on inheritance law. And very recently, he published a large commentary on Swiss inheritance law and a book on actions in inheritance law. Needless to say that we have here a wonderful cocktail, if I may say so, of specialists who will really lead this project. But first of all, we need to understand what is this project all about. And that's why I give you the floor. I think, Antoine, you're beginning, so you have the floor. Thank you.
Thank you, Pascal. Actually, hearing you, you did summarize pretty well the project. We will go a bit deeper. We will tangle a bit with Edina. The main purpose to provide model rules and guiding principles, that's to harmonize, to start with the definition, primary notions, digital remains, access, inheritability. And our aim is to draft a model that will also be able to adapt. We know that technology and laws are not always coincide, so that will be one purpose. One challenge that we do face to start with is really to have the definition of digital remains. Of course, that does cover digital assets, but we know that in inheritance, we may have personal data as well, information that may be requested if you want to go into proceedings. We will have intellectual property issue, contractual issues, and maybe even representations of the deceased. I think of avatars. Obviously, when we talk about digital asset, and given today's world, and that's my daily practice, most of the time you have an international aspect, you have legal relationship with companies abroad. So what we do notice and what we will be facing, that's the clear need to see if the existing rules on jurisdiction and applicable law are still fit for today's world. Do we need to adapt them? Do we need, and that's one question that is at stake, to have the court of the usual domicile of the deceased having jurisdiction, or should it be the jurisdiction decided by the party if we think of any contractual agreement? One example that may happen, think of a judgment where you have a creditor that is being granted a debt that the debtor has to pay. I mean, something quite common. Debtor does refuse to pay. The enforcement officer noticed that the debtor has some cryptocurrencies into his assets. Debtor dies. What does happen? Which law does apply to the creditor? And which law will apply to the heirs regarding the cryptocurrencies? Which court should have jurisdiction? That's one easy example that we're facing in everyday's life. And that's the question that will be raised, and hopefully that we will answer with the team.
Thanks very much, Antoine. I think that's it's my turn now, and then I'll pass back on to Antoine after my contribution. And again, I'd like to say hello and welcome to all the participants and all the panelists, and we're here to learn more about our project and hopefully ask some interesting questions towards the end. So Antoine has given one example already as a sort of a small case study as to what we may be investigating in the project, or what we certainly will be investigating in the project. And I will add another example that is slightly different because, as Antoine has said, we are looking at conceptualizations and definitions of digital assets and remains, and those consist of a vast amount of different assets, data, and what we call digital remains that encompass a wider range of not just traditional assets as we see them in their pecuniary value, but also very personal remains of individuals. So to exemplify those, I will just give you an example that most of you have heard of and have encountered so far in the media, perhaps in your own personal lives. And these are the access to social media and email accounts. So those accounts, as we know, include a vast amount of assets, content, remains, including copyrighted material potentially, or quite likely, then also personal data, communications, and other aspects of deceased identity. They're very interesting assets or remains, the social media and emails for heirs, family members, and friends. And all of them would wish to access parts of that content, as we have seen in the recent years and in the recent decade. However, the laws in most EU countries, and not just EU countries, but also wider, and if you think that Antoine comes from Switzerland and I come from the UK, so that's also, includes examples of countries that also lack clarity, quite a lot of clarity in this area, and as to who can access this content and data and communications, and what happens with very personal communications, which traditionally would attract confidentiality, for example. Also, to go a step further, a further complexity would arise if these accounts are used to create, for example, a chatbot or an avatar that Antoine also mentioned of the deceased, and then this chatbot or an avatar or reincarnation of the deceased then interacts with a family member or a friend, or just a limited group of those individuals. So the question then arises, and that we have asked in our research and will be asking in the project, is who has the right to authorize the creation of such a chatbot? And what data can be used to feed the algorithm that will then produce this chatbot or avatar? Further, who can object to these sort of reincarnations of the deceased? Can the deceased oppose that before death? For example, as we suggested with my co-authors in an article, do not bot me clause in a will is also one of the approaches that perhaps we'll be also considering in the project. These questions may sound like slightly science fiction-like, perhaps to some of us. However, these services already exist commercially, and these chatbots and avatars can be created already. In our business models have been launched to enable their commercial exploitation. And with the pace, of course, as we know that artificial intelligence develops, it is likely that they will be used more increasingly in the near future. So within the project, we also aim to consider these futuristic questions, or the questions of emerging technologies and what that means for the law in this area. And just again to bring this example or case study even more to life, just yesterday there was another piece of news in the Telegraph in the UK where a widow reported that 2 years on she was still dealing with her dead husband's digital legacy. Her name is Hayley Smith, and the digital legacy encompasses a vast range of assets and communications, as they were both very young, so using all sorts of services, and she has really struggled to navigate this area. So therefore, what we've said and what we exemplified for us and our project means that there is an urgent need to provide clarity to each and everyone, including the tech companies, who also report in our research and experience a lack of clarity when it comes to accessing their accounts and the data on their services, their interaction with their users, and of course with laws in various legal systems. So the problem that we aim to tackle is therefore twofold. The EU citizens and other citizens encounter difficulties both when attempting to plan their own estate distribution, but also when they're trying to access and manage the estate of their deceased family members. Because of this legal uncertainty, issues and conflicts arise, and we've seen court cases across Europe and wider, of course. And we within this project aim to address some of these issues, conflicts, and uncertainties. So as we have said, and I think Antoine has already alluded to a lot of, or well, explicitly said what in summary we are aiming to tackle in the project, and I'll just elaborate a little bit more. So the first aim is to provide some more clarity on the mere status of digital remains and conceptualization of digital remains, digital assets, data, and other types of digital remains, because the current situations can be just summarized as legal uncertainty. Because inter alia, this area intersects numerous areas of law, such as property, contracts, intellectual property, and data protection. Also, we will consider different challenges that would arise from diverse national laws in the area of inheritance law, but also data protection law, and that all will relate to this aim of providing more clarity with regards to the status of digital remains and their conceptualization. Further, we would need to provide some clarity with regards to the rules that determine who has the legal right to access and manage person's digital estate and digital remains after their death. So the access and entitlement issue. So in this area, our aim is to guarantee both data security, dignity, privacy of the deceased during data transfer to the entitled persons. And one question that, of course, we'll consider within this aim is whether people expect the same level of privacy for their digital data and communications, online communications, as for their traditional communications, such as letters. Many member states would recognize that digital assets are part of a person's estate and can be inherited by their beneficiaries. However, in practice, this is often very complex and difficult, if not impossible in some cases, because there are many legal and technical challenges that occur when digital assets are attempted or required to be transferred to the appropriate parties after person's death. And some of these questions have been considered in case law, and some of the famous cases have been, for example, considered in Germany with the Facebook case in 2018. Also, regarding the online communications of the deceased that I've mentioned, it is important to be mindful of this distinction between the access to the account or the access to the files and inheritability of those, which inheritability, the latter, is subject to a great controversy and is, of course, perceived very differently in legal regimes across the EU and Europe. So as a consequence, we would aim to provide clarity also regarding the access to digital communications and consider to what extent we can harmonize perhaps also data protection rules and other relevant areas of law. So I will now pass on again to Antoine. So thank you for your attention.
Thank you, Edina. Yeah, the difficulty or the challenge it is that we will have to do it at the same time bottom up, which means look at the national laws, look at the current regulations, obviously at the EU regulation, and top down, which means that you have to clarify the concept, as Edina did say, and work both ways at the same time. To summarize what is clearly at stake, it is what does happen when someone dies to his digital remains, assets, data. Is there any transfer directly to the heirs, no matter what data we're talking about? Do they have ownership or just access to it? As a practitioner, obviously, which law should apply? Even more important, and that's the lawyer speaking, I mean, I'm a litigator, so which court should have jurisdiction? Can the EU regulation help regarding this? And one point that we should not forget, when someone dies, does happen that he did make a will. How do we take into consideration his will regarding, for instance, personal data, online communication? What we will do is making rules for citizens. We will not be making rules for lawyers. I have the idea, we have the idea that law or model rules should be easy to understand or to apply. Useless to say, and I think that we will all agree that for now on, the laws or the challenges that we're facing are A, not easy to understand, and B, applying them, that's the next step. That's a real nightmare as of today. We have one open question, for instance, that I really like, and we do not have the answer yet, but should or would the provisions prevail over any contractual agreement in between service provider and the deceased. Would, for instance, the deceased domicile would be the place of jurisdiction rather than the contractual place of jurisdiction? That's the question that we are raising. At the same time, that may help, as Edina did say, the tech companies. As of today, we know that any court case with the tech companies are cost consuming most of the time, and that's what I teach my students, or what I tell my clients. You end up in the States having a jurisdiction in San Diego or Sacramento, and obviously by these last example, you may see that we will run into some private international law issues and recognition, and that is the project that we just started. And I have to say that 2 years ago, if someone had told me that that project would be in place, I would not have believed it. And I'm really looking forward to face that challenge, and obviously can come up with some model rules. Thank you.
Thank you very much, Antoine. Thank you very much, Edina, for these first thoughts about these projects. One would think first that it is all about inheritance law. And when listening to you, of course, we realize, no, it's about many other aspects: data, IP, access, and of course, l'Union Internationale des Huissiers de Justice has a specific code on how to implement the access to assets, and that might be also an important aspect of these rules. I'm sure we will get many questions, so many specific questions here, and at the same time, probably you will not be in a position to deal with everything at the same time, but a number of aspects pop up, and I'm sure that will be fascinating. But first, let us have some comments on this project from an academic perspective, first by Sergio Camara Lapuente. He's a professor of private law at the University of La Rioja. He's an author of a handbook, 2 monographs, and many articles on succession law. He's also the president of the International Academy of Succession Law, which includes academics from more than 11 countries. And he has been invited by the European Commission as an expert for the review of the draft regulation on succession law. He has many memberships also into the expert network of the World Economic Forum. And he's also a member of the ELI since 2012, member of the advisory committee on a couple of projects, including the one on access to digital assets, and member of a high-level expert group on digital inheritance. So we are really thrilled to hear what you have to say, Sergio, and I'm pleased to hand over to you.
Thank you, Pascal. And first and foremost, I want to express my gratitude to the co-reporters for their boldness in agreeing to lead such a highly complicated project as this is. I wish them courage, strength, and inspiration, because there is a whole changing world to map and regulate for the first time, really where angels fear to tread. So complexity is so obvious that I won't say a word about it. As a scholar who has been asked to comment from an academic perspective, thank you, Pascal, for this assignment, almost the first thing I have to look at are the sources. The sources used in the feasibility study presented to ELI on this project are indeed the relevant ones. I would add, in order to focus today's topic, the foresight of the European Declaration on Digital Rights and Principles, approved last December in 2022, in whose 19th digital right is established this: everyone should be able to determine their digital legacy and decide what happens with their personal accounts and information, only that concerns them after their death. Even this programmatic statement has a narrower scope than our project, but there is a clear advance with respect to the scope of the GDPR. There are indeed other proposals and projects dealing with digital assets, such as the ELI project on digital access, the UNIDROIT principles on digital access and private law, and the UK Law Commission on Digital Assets, with valuable rules but very different objectives. However, it is interesting to note that the Law Commission report published last year announced the need of a new project, a separate project, on the rights of access on death and incapacity. In particular, with regard to social media accounts, email accounts, and other end-user license agreement-based accounts, which, according to many stakeholders, would be also capable of passing on succession. This is a key issue, and therefore, our project is on the right track. The focus must be on inheritance law, which has enough peculiarities per se to merit full attention when combined with the enigmas of digital elements. So, now I would like to structure my remarks on the initial approach to these model rules through the 5 W's: why, what, who, or better to say whom, when, where, and how. Take 5, 6 questions, 1 minute each, difficult to post it all together. First, the why. This has already been answered by the co-reporters, and I fully agree. So I go for the what. In principle, I agree with the ambitious approach of including as a target area of the project a digital estate that includes not only digital assets, but also data, personal and non-personal data, and digital remains. This tripartition deserves to be explored and is original. It encompasses in a single set of rules the patrimonial and the personal, but I would like to point out a few general issues. The purpose of making classifications is because it is possible to find some rules applicable to all items and others specific to some. Therefore, it will be necessary to see if there are such common rules. There are at least 2 triads of notions the co-reporters propose, and although I have no time now to go into details, I think there may be overlaps and they should be further refined to see what goes into each one. For instance, digital assets, digital inheritance, and digital remains. Digital inheritance refers to transmission, not to the object, and should be probably better defined. And the third, digital remains, from my point of view, should not include digital assets again, and should focus on non-personal data, avatars, and so on, to make a good taxonomy. It is a very good starting point to consider the concept of digital assets in the early principles on the use of digital assets as security. There is a lot of effort and wisdom put into this, and it brings together ideas that are gaining ground, such as electronically stored record, controllability, and transferability. But perhaps we should consider, for the purposes of this project, to narrow the concept with the notions of exclusivity of control, excludability, or even the rivalrous nature of the asset. Third question, who? Indeed, who? It is clear the title holder of the digital assets is the deceased, and it's a matter of his or her succession. But one of the most serious problems with these model rules is who should have access to these so diverse items after death. In the tradition of many countries, while it is clear that the heirs or executors are the only ones who should have access to what is inheritance in the strict sense, digital assets with patrimonial value, when it comes to personal data or protection of the image or honor of the deceased, special laws not only give heirs access to them, but also relatives in general in very broad terms, or even, if I can quote the absolutely excessive Spanish law on this, to persons linked to the deceased for family or de facto reasons. To give an enlightening example, in recent Italian judgments, the spouse has been granted injunction to access the deceased Apple account on the grounds that he or she is the spouse, not the heir. In such an account, there may be patrimonial assets and personal data. In iCloud, there may be stored works or diaries, a mixture of everything. So imagine the following case. The spouse or any son or sibling with whom the deceased is not in good terms, having the testator appointed a son or a friend as heir, access OneDrive or iCloud under the protection of their status as relatives, and delete works protected by intellectual property or data and passwords that allow access to wallets. In short, access to digital assets that the heir is entitled to receive. How can these conflicts be avoided? With a model rule. One strength of this project would be the breadth of the digital estate covered. In this sense, it could be proposed that after death, only the heirs, designated by will or by law, could have access to the deceased account, not any relative. And this brings us to another crucial decision. The value, and Edina pointed it out before, the value to be given to the fact that the testator has not made any provision for the digital estate. There are two approaches for the time being. Either relatives will be able to access unless prohibited by the testator, or they will be bound to do so in a sort of dignified digital death, unless express permission by the testator. I am much more in favor of this second orientation, always leaving the caveat that the heirs or executor, not any relative, have the right to access the contents that may form part of the estate, or to the information that makes it possible to find out how to access those contents. In short, if I may use a sentence that is so familiar to us all on flights, we can coin this expression: don't forget to take your digital belongings with you. Or please, let's ensure to draft a default rule that is as non-invasive as possible for the privacy of the deceased. My fourth question is when. Obviously, the decisive moment is death, but there is an earlier moment that is crucial. The moment of accepting the general conditions of the internet service providers with the click of a button. And this must be another of the great and brave decisions of these model rules. Non-negotiated standard terms should not take precedence over mandatory rules of inheritance law and the basic principle of passing on everything that belonged to the deceased. It is not the same thing to transfer a contractual relationship during life to a third party as is to surrogate an heir to it. And as the judgment of the German BGH of 2018 rightly stated, these are not non-transferable personal obligations. So therefore, we should propose reform not only on the regulation of succession law, but also GDPR and also Directive on Unfair Terms or the future Digital Fairness Directive in case. If we think of two examples in the industry practice, we can arrive to another conclusion. The first unusual scenario, in it, the online provider prohibits everything. For instance, in video games, Blizzard. You may not transfer your rights and obligations to use the platform. That's it. In the second scenario, some platforms enable a legacy contact. We all know Facebook, Apple, and now even Google. But the appointment of this special fiduciary for each account is voluntary. If nothing is provided, normally access is simply denied, or we have to go to the court of the United States, as Antoine said. So let me read the typical no survivor clause, for instance, from Apple. Except as allowed under digital legacy and unless otherwise required by law, so law can do a lot here, you agree that your account is non-transferable and that any rights to your Apple ID or content within your account terminate upon your death. Upon receipt of a copy of a death certificate, your account may be terminated and all content within your account deleted. So there are many ways to act through the legislation against this. And final point, because I'm out of time, I think, minute, if I may, Pascal. How? There are many questions to be asked here. How to transmit the digital inheritance, how to order this effect, how to prove the beneficiary or the administrator's capacity, how in short to articulate all these model rules. First important thing is to draw a distinction between access and power of disposal. All the projects I have mentioned have control and transfer, but maybe we have to shape a bit more those concepts as adapted to inheritance law. Second, how can a deceased person order these effects? In my view, a will fully validated in accordance with the formalities of each country is the most suitable instrument to appoint a digital heir or executor. A different question, but ultimately a factual, not a legal question, is how to transfer keys to access digital assets or digital accounts or services, for which the ordinary will is not the best instrument. Access to email, important but restricted, of course. And there are also doctrinal proposals on blockchain self-executing wills, or entirely digital wills. But I think we should leave at this early stage those devices. So my bet would be the primacy of the will or certificate of interstate share. And I'm absolutely out of time. I would formulate some principles, but let's leave it for the discussion. Thank you so very much for having the privilege to speak today, and I look forward to other speakers and to discussion. Thank you.
Thank you very much, Sergio. And of course, you will be involved in also further discussions. So your ideas on further principles will certainly be useful. I was just listening to you. I was just wondering how big the project might become with the time going on. And so certainly good luck. But I'm sure Antoine and Dina will pick up some of your thoughts also maybe later on the Q&A. But first, we wanted also to have comments from a UK practitioner's perspective, so to say, and that's why we invited Lee Sagar. He is a barrister of England and Wales with a very large practice, including, trust, estates and commercial advice and litigation, administration of digital information, and we have seen that this is central, but also administration and taxation of Bitcoins and other cryptos, tokens, including also NFT assets and related litigation. He is a member of the Society of Trust and Estate Practitioners. He's a member of the ELI and also the Association of Contentious Trust and Probate Specialists. And Lee is one of the editors of a book called Williams, Mortimer and Sons Writing on the Administration of Digital Information. Has written a book also called The Digital Estate, so to say, the Bible for our co-reporters potentially. And that's why I think it will be very interesting to listen to you too. Lee, you have the floor.
Thank you, Pascal. I think this is a very important project. I and colleagues of mine who have been involved in the Digital Assets Special Interest Group of STEP, the Society of Trusts and Practitioners, have been thinking about the objectives of this project for several years. And I'm very pleased that this group and the reporters are tackling the issues. To me, the idea of personal representatives and those with powers of attorney in the event of incapacity not being able to access the content of cloud services accounts seems to be unjust and unreasonable. I therefore support the project. English law, of course, approaches these questions from a property point of view. One of the main difficulties in this area is the definition of digital assets. To an English succession practitioner, an asset gives property rights and interests, but this is not necessarily the case for digital assets. There is a tension under English law, therefore, between, on the one hand, electronic signals in a computer, which constitute pure information and are not property, and no access to those signals in somebody else's computer can be claimed by right by personal representatives of deceased persons or attorneys of persons who are mentally incapacitated. On the other hand, there are rights and interests that are associated with the information that is constituted by those digital signals, such as copyright, but that does not give access to the content of someone else's computer, or contractual rights, which may give access depending on the terms of the contract as interpreted in accordance with the law governing the contract. Very often, obtaining access in England requires the bringing of proceedings for that purpose in the courts. As Sergio mentioned, the Law Commission of England and Wales recently examined the law relating to digital assets, and they looked at this tension that I mentioned between information and property, and they formulated a test for what they called a data object, where pure information may be in some way considered to be property. The test was firstly that the digital item must exist independently of persons and of the legal system. So that knocks out contracts and debts, which are fundamentally obliged, where a person is fundamentally obliged to go to court to recover their asset. The other requirement is that it must be rivalrous, which means the use of that item by one person prevents or prejudices its use by someone else. So if I'm holding my mobile phone in my hand, nobody else can hold it at the same time without, of course, fighting me for it. Digital items such as crypto assets do comply with these conditions so that they can be considered to be things and give property rights and interests. By way of an example, a contrast can be made between an avatar that is built into an online game, which does not give any ownership to the user, and a non-fungible token, which can be owned and which is designed to be used as part of an online game. There is a tendency today for people to consider that they're entitled to use the usernames and passwords of others to access online accounts. In England, and I suspect that this is the case in many other jurisdictions, this can result in the commission of a criminal offense and should be avoided. But in my view, this method of accessing online accounts should be considered as a possible pathway through the current gateways to access, provided, of course, there are sufficient controls and regulations. Of course, this requires legislation and cannot be given by guidelines. Thank you, Pascal.
Thank you very much, Lee. Thank you very much also for this very careful distinction between, assets, information. Listening to you, I was just thinking how much we traditionally make a big distinction between ownership and contract, at least on the continent. And maybe through digital remains, this distinction is blurred to some extent, or must be at least reaffirmed, maybe, in order to make things clear. But indeed, that will be an important discussion, and we will certainly come back to this during the Q&A. Thank you very much for this. For these comments. We'll turn now to Chandra Kramer. She is the head of the so-called MCC membership consultative committees, because all ELI members have the possibility to say, I'm very much interested into this project. I would like to be able to receive drafts, to be able to react, and so on. And therefore, we thought it might be important to have the chair of this group of people here to promote also the idea that ELI members join the MCC group. But Chandra Kramer first is, of course, a professor of civil justice at the Erasmus University in Rotterdam. She is also a deputy judge in the District Court of Rotterdam. And for the ELI, she's also a co-reporter for a project on digital justice in private law, in civil law, sorry. And so she is, of course, also directly linked to this idea of digitalization of the justice system on the one hand, and then therefore also on these various aspects. I don't want to expand too much. Of course, Chandra is also a member of the ELI Council, where she has her say on the project and had also to vote on the acceptance of this project. But I want to give you the floor immediately, Chandra, so that you can present your thoughts and maybe also the innovative aspect of this project. You're welcome.
Thank you very much for this kind introduction. First of all, my congratulations to both project reporters. I've expressed that earlier also last year at the ELI Council meeting. I think the two of you have done a tremendous job in writing the proposal, but also further refine it. I think it's also very ambitious, and we've heard also from the other speakers that, I wouldn't say it's over ambitious, but we have to make sure that it stays feasible because there are so many different angles, and it also has to be finalized at some point. I think this topic of digital succession, as we call it, is very fascinating, but we've heard also that it is extremely complicated. It's very technical, but at the same time, and that's why it is also so interesting, it is very close to us, to all of us, because, well, we know that we will pass away at some point physically, but then our digital inheritance may continue. Sometimes we want that, but sometimes we don't want that. And of course, as we also know, it may also be discontinued, whereas heirs or the deceased may have wanted to continue using those data and being existent online. I think that the project is very well timed, of course, because many jurisdictions and practitioners are now dealing with these problems, and it is very good to have an overarching project like this that combines a lot of expertise from different angles and can bring it forward, and can be also then perhaps a model guideline for legislators and practitioners having to deal with it. I think it's innovative in different ways. Of course, it's very wide and interdisciplinary scope, which is also a risk, as we know, but you should start broad in investigating what is all out there. And it, of course, encompasses the law and technology, but also, and we've heard that succession law primarily, but also property and contract law, matrimonial property law may come in, privacy law, data protection, internet, and of course also, and there's also one of my key areas of expertise, private international law questions, because, well, we all move, but especially our digital data tend to be moving cross borders or even worldwide available. A second innovative aspect is the comparative aspect. I think that's very interesting, and that can also feed indeed the project bottom up to see what is out there in the different countries, what practices exist, and then for that purpose also involving many different key holders, key stakeholders is very important, as we're also doing. And third, and then I believe the project can also contribute, and we've heard a little bit about that already today, is to sort of counterbalance the power that now lays with mostly private service providers. They govern our data because, well, we entered it and we clicked yes because we were eager to use a certain platform or program. But that also means that those companies, those tech companies, have a lot of power. And I think a project like this, and of course a regulatory framework, would also help in counterbalancing that, and to see how a person can also gain back control, and how after someone's death, heirs can gain back control. Well, I don't claim to have a key expertise in this area because it's very complex and it goes into so many directions, but I hope to add my 2 cents to this project by chairing, as Pascal has mentioned, the Membership Consultative Committee. We call it the MCC for the ELI. And I warmly invite everyone that is interested, both individuals and also institutional members, to help shaping those projects. The MCC is also open for non-ELI members. Of course, we hope that members that are interested in the projects of ELI will also join the ELI, but also if you are not yet a member, you can become a member of the MCC. And the role of the MCC is, Pascal already mentioned this briefly, is to provide comments on drafts at the various stages of the project, give some guidance and insights from particular angles, whether it's privacy or data protection or privacy international law or succession law, or maybe your technical insights into certain matters, cybersecurity. All those aspects are important and can contribute to the project. For MCC members, in how far you get involved and how much time you dedicate to that, that's up to you. It can be minimal, you're only interested in a certain part or giving some feedback, while others become involved more extensively. We will have 1 or 2 online meetings, but also you will have online possibilities to share your views and comments on the draft. So that is very helpful for everyone. We expect that the project team will develop a first, of course, the ELI Council already saw the project proposal, but now we are working towards a few first draft that should be available then in the next months, but I don't know exactly what the current timeline is. That's maybe a bit ambitious. And well, of course, if you want to contribute, especially after a first draft has been is ready for publication or within limited range will be published, then yeah, we hope you will help us. So please express your interest in becoming a member of the MCC, and you can do that by sending an email to the Secretariat, and the Secretariat at europeanlawinstitute.eu, but also at the project website. You will easily be able to access the relevant information on the project, on what the MCC membership entails, and how you can contact the Secretariat. So I hope you will get involved if you are participating in this meeting, and yeah. Thank you very much for that in advance.
We hope so. Thank you very much, Chandra, also for your thoughts about the innovative aspects. We got a number of questions, and maybe before getting to the 2 specific questions, maybe I can ask Antoine and Edina whether they want to react on some of the statements that have been made by Sergio, Lee, or Chandra, so that you have a right to be heard, so to say, also on these aspects. So maybe Antoine, do you want to begin, and Dina follow, or the other way around? I'm fine.
Thank you. Yeah, I mean, to summarize, we know that the project is quite broad and the questions raised are quite large. And obviously, I mean, we're facing a few challenges given all the tasks that we will need to achieve to make or to propose easy to read and to apply model rules. That's really the main purpose. If we said that we will do it bottom up and top down, it is that we will not reinvent the wheel. Obviously, I mean, there's some legislation at international or national levels that may be used. There's some concept that needs to be clarified. It's true that depending upon the countries that will change quite a bit. I would say that we have, because it's not only Edina and I, but we clearly have a dream team, if I may say so, the project team, and we will meet for the first time in Budapest beginning of March. Actually, I mean meeting in person and not through Zoom. And given the qualities and the expertise of the other members of the team, I do believe that we should be able to come up with model rules that will give answers to the worries that have been, or the questions that our 3 speakers have raised, or that the questions we have in the Q&R. But obviously, any help is welcome. And we will be looking forward to any comment after the first draft. not in a couple of months, but I hope in a few months.
Very much, Edina. If you want.
Yes, I'll just briefly. Thanks, Pascal, and thanks, Antoine, for your response. And again, thanks to all the panelists for their really valuable comments and support for the project, and for some praises that we've also heard, but also provocations and all the positive, of course, and constructive that we have received. So I think I would like to first thank Sergio for how he structured his contribution and some thoughts and challenges with regards to the project, but also some ideas and proposals as to where we should be perhaps looking at or thinking in terms of providing solutions and examples that he's given with regards to the primacy of the will and certificate of interstate and the conflicts between non-negotiated standard rules in contracts versus mandatory rules. I think that's all some of the crucial aspects of the projects and some of the questions that we have also discussed as a project team before we started the project, before the approval of the project and the official start, but also that we'll be discussing in much more detail, as Antoine said, in Budapest in our first meeting, and hopefully providing a first draft shortly afterwards, after this meeting. So Sergio is also in our advisory committee, so we will be definitely hearing hopefully much more from him and his useful ideas and contributions. So thanks again, Sergio. Lee, again, thank you for your contribution from the UK, and very practical, and your experience in this area is really vast and very long-standing, and we've known each other for some time, and I've been following your work within STEP and outside. So STEP is also on our advisory committee, and we look forward to receiving feedback and input from such a wide global organization that includes lawyers from across the globe. And also, I think what Lee has said with regards to property, questions of property, and bringing in the common law perspective and the work of the Law Commission, I think is also valuable. And I've also spoken myself to the Law Commission recently, where I challenged their approach with regards to the reform of the law of wills, where they again exclude digital assets in considering this area in more detail in England and Wales, but they promised that this is on their agenda and one of the priorities. So let's see what happens. But I think that there needs to be some synergy, and will be some synergy between our project and the UK's efforts there. And I think we'll be looking to for Lee's support if he can provide it in the future as well. So thanks very much. And finally, from Chandra, again, thank you for your contribution. We look forward to the contributions of the committee and of the group that you'll be chairing, and hopefully including participants from today's webinar. That will be, again, really, as Antoine has said, we may be a dream team, and we really work together already quite well as a team. But having this broader, much wider input from so many different perspectives from the committee will help us navigate our thoughts and make the project, from on the one hand, more viable, but on the other hand also more more impactful, and having a buy-in from a diverse range of stakeholders for us is really important, and we will look forward to working with those different groups and individuals. So yeah, that was just my response, and I can see that there are quite some questions there. So
yeah. Basically 2 questions, but one is on 3 layers. But thank you very much, Edina. And indeed, I wanted to take the first question because when we spoke about contract and assets and information, first question says, yeah, the recent practice with Google is that if you don't use your account for 2 years, it disappears. And so there might be nothing to speak about after 2 years. And you spoke about heirs, and of course, if there's an automatic designation of a heir because it's a descendant, for instance, that might be easy, but sometimes you do not have an automatic designation of a heir, or it is contested. It may take many, many years, and then you might see some tensions between, you know, the contractual aspect of deleting based on standard terms and conditions, deleting the account and therefore all the information, but maybe also assets that are in, and the issue about digital inheritance. So I think that's an interesting aspect that goes in line with what was said before. And of course, we are at the kickoff webinar, so we are not expecting you of giving us, you know, the final answer, but maybe maybe you want to react to this question, because of course you have this tension between giving information to the platforms, as you said, or as was said also by Sergio, and at the same time, of course, standard terms where you agree, you gave consent. Sergio said, yeah, but the central aspect might be the will. Yeah, fine. But what if you come too late with the enforcement of the will? And how would you see a way to get over this hurdle, if I may? You want to, I don't know whether Antoine or Edina wants to. Edina, please.
Yeah, I could start. Thank you, Ian, for this question. And again, Ian and I know each other, so yeah, we've been having similar conversations previously. And Pascal has already alluded to some of the key questions and tensions here. So. Well, yes, we have had problematic behaviors, terms and conditions, and practices by platforms, not just in this area, and we've seen it increasingly in this area in the recent years, also regarding the court cases that we've seen. But we've seen that problematic behaviors in so many other different areas that relate to the living users, data subjects, individuals, etc. What I can say here is that, again, we can't just perhaps embrace this maybe defeatism and say that, you know, we have already relinquished our rights and we're using these platforms for free, so they can control the right to do, and they can do whatever they want with our data and other and remains. And we've seen that for the living individuals, this has been addressed and countered in many areas of technology law so far, including data protection. And we've seen regulatory action across the EU as a result of GDPR and other laws, and increasingly now the AI and other aspects of digital services. So I think what needs to be done here is, well, on the one hand, having conversations with these platforms, and this is what we are going or try to do in the project as well, and see what they deem viable and how they perceive our efforts. But on the other hand, also, devising mandatory rules and creating rules at the EU level or member state level in the area should produce effects on platform behavior in these areas as it did in other areas of technology law and regulation more broadly. So I think that we will be producing those rules, and what Sergio also mentioned with regards to the tensions between standard clauses and contracts versus wills and mandatory rules is something that we'll be looking at, and is something that would be looking to address this behavior by the platforms. And on the one hand, perhaps maintaining those records for longer, and keeping these remains so that they can be disposed of as per mandatory rules and other and principles and wills, etc. But also providing clarity to the platforms, because from my experience with the platforms, they also lack clarity in this area, and they would welcome, perhaps not always, but sometimes some clarity. So let's see how this unveils in this area. But I think it's well, one thing is conversation with them, and the second thing is just coming up with some mandatory rules that are lacking at the moment in this area, and see how we can enforce them.
Thank you very much. I will give the floor to Lee, but just a reaction. I think this project cannot solve all the problems. And so the inheritance law perspective, or even GDPR perspective, whatever, but we will not be able to solve the problems that are already there before. And the mere fact that someone is deceased, customer of a platform will probably not make it feasible to change all the rules of the game, so to say. And of course, some of the issues are valid also for non-deceased users, if I may say so, and that's probably also a difficulty. Lee, you have the floor. You wanted to react.
Thank you, Pascal. From what my experience, the problem here is the contract. And so most of these, the providers that people use are somewhere in the United States of America. And, for a provider that's in England, there's usually not that much difficulty. But for an American provider, they have specific laws that say they can't give information about an account to anyone but the person they have a contract with. And if the person they have a contract with has died, then they can't give it to anyone. And so that's why there's a problem getting information from America. Many states, including California, have now made laws which allow people to get information, but they have to go to court to get an order of the court, and whether they get an order and what order they get depends on what's in the will and other provisions of the contract. And so that's the difficulty that has to be got around, not necessarily whether there's a will or not, because the will can give whatever it wants. The question is, can it get access to the account? Thanks.
Yeah, thank you very much. That's very important indeed. Sergio, you wanted to react maybe from the EU perspective. I don't know whether you want to mention the DSA, but that would be a good idea.
Yes, I just wanted to add that that national mandatory law is effective, is demonstrated, for instance, just by finding in the general terms of sites like Microsoft, I've seen this, our Steam video games platform, very important, in clauses addressed to the whole of Europe. They state, if French law is applicable, the user can send instructions and so on and so on. So, of course, the Loi de la République numérique and so on, they put that. It's in other countries as well. It's in Spain. But the US servers maybe have received too many claims from France, but they have put in the general conditions for the whole Europe, only if you are French or French law is applicable, then you can send instructions. Just for a hint of how mandatory law can be persuasive to some platforms. Just that.
Interesting. Thank you very much. That's an interesting aspect. I wanted to get to the second question, which is a more fundamental question linked to so-called fundamental principles of private law. And if I read, it's quite a long question, so I'll summarize it. But if I read it correctly, it says, well, we have, correlation between personality law, inheritance law, and this interconnection on the level of digital law brings the fundamental principles of private law maybe to their boundaries. And the question is, should we stick to these fundamental principles of, let's say, private law that we inherited even from the Romans, so to say, Roman law times, up to now, or should we fuse them into a new type of law for inheritance for digital assets, making it, of course, then more difficult to align the digital inheritance with the non-digital inheritance, not speaking about revalorous, non-revalorous assets, but already that. So what is your feeling and your perspective, Antoine and Edina, on that issue? How do you see that?
Well, I don't see it feasible to, just have one concept. What I understand from the question itself, it is actually we do need some help to clarify how we deal in between digital assets, digital data, who does inherit them, or do we inherit them? How do we access to them? And clearly, if I would summarize an answer or my understanding of the question, it is we have obviously in every single country inheritance regulation and data protection on whatever level. That's for the inheritance for person who did die, data protection mainly for person who do live. In some countries, it's already taken into account what does happen after the death. B, in most countries, we have the fact that property or asset go to the heirs and personal data question is open. Okay. And C, and that's really as a practical matter or as an emotional matter for our citizen, it is rather than property is access to the data. And as a lawyer or an attorney, it's access actually to the information, because we know that when we have to fight in court, and I'm thinking of emails and so on and so forth, which is maybe not an asset itself, but you need to get access to the information to be able to throw a court case. So the purpose or the focus of this project, that's not only to have broad and general concept, that's really to have, I will say it in French, but les mains dans la gadoue, I mean, to have something concrete that will actually help practitioners and citizens. And I like the question with the 50 shades, what was it? 50 shades of access rights. I agree. I mean, that's a quite complicated question, but the purpose is precisely to give benchmark and a way of dealing with this, if that does answer the question.
Thank you very much. Anyone else wants to add something? I think this puts really the finger of an important aspect. And you said also in your introduction, Antoine, this bottom-up dealing with comparative law, trying to find, commonalities is essential, is not sufficient, of course, but it's certainly a way to begin with something. Now we have a further question also linked to this idea of data dignity and the idea of, well, I have some, it's not just IP rights, but I might have also some aspects on my digital remains that triggers some aspects of dignity. We have that, of course, in non-digital world, so to say. Would you think that this will also be covered in your project? Edina, you want to react maybe?
I think so, yes. Thanks very much, Khadija. That's a great question and something that I've been working on personally for quite a while so far in considering the question of post-mortem privacy and post-mortem personality rights and looking at the human rights dimension as well as dignity, identity, and other aspects of digital remains more broadly. So I think definitely is a big concern and consideration within our project, and it's something that I personally feel strongly about and will be arguing for to find its way within the scope and the rules in the project. And of course, it was one of the feedbacks that we've received from the council as well, that that it's welcome to not just consider digital assets and the questions that are perhaps a bit more familiar or perhaps easier to some of the traditional lawyers amongst us, but also considering how these interact and interconnect with human rights aspects, dignity aspects, and all of these values, that personality values and identity and other broader values that we need to consider when we talk about the digital remains, as we call them, that encompass not just assets and not just patrimonial value, but much more and beyond. So definitely a big concern, and something that we'll be looking at in the first meeting and further down the line. So thank you for the question.
Thank you very much. Antoine, you wanted to add something? No.
No, I think Edina
Okay,
did cover
because
everything.
I have a further question, and of course we are happy to get more questions. We still have a little bit of time. I have in the project on digital assets as security mentioned by Sergio as well before, there was one important principle to deal with the interconnection between the digital world and the non-digital world. And Lee mentioned, of course, the issue about non-revalorous or revalorous asset, rather. So assets that if one has the digital asset, the other cannot use it. But of course, when you speak about two worlds that are in parallel, and I'm not speaking about many digital worlds, but that could also be a possibility. But when you have a non-digital and a digital world in parallel, the question is also, how is the interaction? And in this project on digital asset as security, the issue was to determine which one prevails over which one. And the answer was, let's go with private international law. Mainly, I'm summarizing it here, but let's look at private international law, and let's have the specific domestic law decide that. So it was a bit a hands-off approach, but of course it is a central issue. Thinking of, for instance, a claim for reduction of some aspect because you gave too many items, assets to one party and not to the other. How do you take into account the digital world asset, an NFT, for instance, in the non-digital world, or the other way around? And that might be a tricky part. So I was wondering whether you had already pre-understanding how to deal with that, whether you wanted to say, okay, let's go through private international law, and we cannot find one single principle because digital law is, inheritance law is too complex or too diverse, or whether you have already some ideas. I don't know whether one of you wants to answer, or maybe the others, Sergio or Lee, you're also welcome, of course, or Chandra. Yes,
If I may, the security and digital assets, I mean, those refer mainly to the concept of control, possession in the real world, and control in the digital asset world. Regarding digital inheritance, seems to me, and actually we did split a bit the work for our questions, and being a litigator, I was happily chosen, or happily chose to deal with jurisdiction and the applicable law. But to answer your question, Pascal, at least under Swiss law already now, if I have a painting that did belong to the deceased domiciled in Switzerland, but that painting is in France, when the deceased was alive, I would have had jurisdiction in France. I have to go to the place where the person is holding the painting. Under Swiss law, when someone dies, I would have jurisdiction in Switzerland at the place of the domicile of the deceased already now for the real world. So maybe you see where I'm going. It is that I do believe that obviously death is an important matter in one's life. So, but that does change or may change the roles. And clearly, at least at this stage, but not please do not take it for granted since we do start the project, but the idea is probably to have as much as possible one applicable law to the entire estate, whether digital or real, and one place of jurisdiction. So that maybe does answer a bit your question. That's much easier regarding inheritance because most countries already have one place of jurisdiction. I put aside the EU regulation saying that I'm half French and half Swiss, saying that France could have jurisdiction because I have a house in France, and since I'm French, we all know that type of regulation, but that would probably be the idea, if that does give you a first answer.
Yeah, sure. Thank you very much. Lee, you wanted to react as well.
Yes, I remember when I first started thinking about digital assets, there was a case in America where somebody had died and his parents wanted to get hold of his emails, and so they had to go to court to try to get access to the emails. And as I recall, they eventually won. But one of the big conversations in the case was, well, what if there's something in those emails that he doesn't really want anybody to know about? Should his parents find out something about him that he didn't want them to? And that was really interesting. But what you think about it is really, if he hadn't had email and he'd just written letters, those who came after him would have gone into his house and found all the letters, and they would have seen all of this stuff unless he had destroyed it. So, in a sense, why shouldn't they have access to it if just because it's digital? But it does provide an opportunity for people to have some more privacy than they might have had in the real world. And I think it's an interesting question, and it's not something that we can answer easily.
Indeed, thank you very much. And everyone remembers some artists saying, once I'm dead, please destroy all my paintings or all my songs or whatever. And sometimes it is done and sometimes it is not. And in infringement of whatever post-mortal personality rights. And that's certainly also one aspect indeed. I think given the time, we are getting to an end. So I want to give last round floor to maybe Antoine, Edina, but first maybe to all three other panelists, Sergio, Lee, and Chandra. And so I give first the floor to Sergio, then to Lee, then to Chandra for a very short final words, if I may say so.
Thank you, Pascal. Of course, you have mentioned the Kafka case, no? For instance, where the executor was a betrayer. No, I was thinking of a couple of points Antoine said before about who are those model rules addressed to? Citizens, lawyers. I think model rules would be more for citizens, for lawyers than for citizens, and make practical rules really not being in the heaven of concepts. I think we could have a compromise solution between them. For instance, in the UNIDROIT principles on digital assets and private law, they have, and this is very common in many principles, an article devoted to principles. So why not to select the 3, 4, 5 key points you would say to any legislator, this is crucial, you have to take a decision on this. We say this is the solution, but anyhow, you taking those principles in one article, you could take another different one, but those are ours. And then in the articles, very tiny practical solutions on the main issues covered by the principles, because otherwise this is a monster of project. But that's one thing, and the other one, very shortly, I think the holistic view you have adopted is very interesting to be explored. I mean, both fundamental rights and digital assets, do not leave that. The question is whether we should give very different rules or maybe not so different rules, putting the focus on executors, personal representatives, or heirs. That's it.
Thank you very much. Lee?
I just wanted to say that this is a big project, but it's a good one. And I've already joined the members consultative committee, and I am, I hope that I'm approached to help if necessary. Thank you.
Thank you very much. Sandra, as chair of the MCC, is already pleased to hear that, but she has certainly other things to say as a final word.
No, I just want to wish the reporters good luck in managing the project successfully. And indeed, if participants are interested in participating in the MCC, then please send an email to the Secretariat. Thank you.
Thank you very much. Edina and Antoine, you have the final word. So I don't know. Edina, do you want to go first?
Yes, well, again, just briefly to thank all the panelists for their comments and contributions. And it seems that we'll be working together with all of them. And I'm really looking forward to that. And of course, it's an exciting but also very challenging and complex project, and we'll need as much support and as much input as possible. And for Sergio, I absolutely agree with your approach and what you've suggested. And that's also where my thinking has lies so far. So thanks a lot, everyone. And thank you, Pascal, for chairing and your contributions.
You're welcome. Thank you very much. Antoine?
Thank you, Pascal. Yeah, thank you for all your contributions and thoughts. And obviously, I mean, any input will be taken into account. I'm really looking forward to work with Edina and all of you on this project. We do know it's quite huge, and that's why we precisely need you to see if we're always or still on the right track. And to answer one question, I mean, it's due by October 2025, I do believe, Pascal.
Yes, indeed. There was a question about the time frame, and usually ELI projects on a 2-year time frame, but then sometimes we have to decide, whether this is sufficient or not. But it is good to have a good pace forward, I think, and also because that, things are evolving very quickly, so we can always revise principles later on if we realize that things have changed so much.
Thank you.
I didn't want to cut you short, but I think you're over with your last statement. So I wanted to thank you all from the side of the ELI. First of all, of course, the 2 co-reporters. They still have a lot of work in front of them, but I think we can hear there's already a lot of thoughts that were put into their draft proposal, and so I'm really confident in the pace and the issues, how they will evolve. But thank you also to all 3 other panelists, Lee, Chandra, and Sergio, because this helped us a lot to see it in a broader perspective. Lee, you are totally right. One needs not forget, the US law and also the common law, of course, in these issues, because the perspective is quite different. And if I remember correctly, we have, for instance, the digital will that has been prepared through principles by the uniform law commissions in the US, I think, and so there are still a lot of things here that we could benefit from in our project. Thank you very much also to all the people who attended this webinar. This webinar is recorded, so it will be made available. And of course, do not forget to register to become an MCC member, because that's also a way to bring in your specific expertise and to react and be aware before the others of the issues, the problems, but also the solutions. So thank you very much to everyone, and enjoy the rest of the day. Thank you. Bye-bye.
Bye.
Thank you. Bye-bye.